When debt becomes handcuffs, how people still land in jail for owing money. 1. The myth of freedom from debt prison. Most people believe debtors' prisons vanished with powdered wigs and horse-drawn carriages. Unfortunately, that's only half true. The United States technically abolished imprisonment for debt, yet people still find themselves behind bars because of debt. So what does that actually mean? It means the system changed the label, not the logic. Footnote. This section introduces the paradox that although debtors' prisons were outlawed, debt-related incarceration persists through indirect legal mechanisms. 2. The legal loophole. Here's the twist. You can't be jailed for owing money, but you can be jailed for what happens after you owe it. Debt collectors file lawsuits. Courts issue summons. Ignore that summons, and the judge issues a bench warrant for your arrest. You're not jailed for debt, you're jailed for failing to appear. It's a word game that still ends with bars. Footnote. This section explains that modern debt-related incarceration arises from procedural noncompliance, such as contempt of court or failure to appear, not from unpaid debt itself. 3. The real-world examples. Certain debts trigger direct consequences. Tax arrears? The IRS might prosecute. Child support delinquency? Jail time is common. These are the official ones. The unofficial ones come from civil courts, small claims, municipal fines, private collection suits. Skip your hearing, and a sheriff may appear with an invitation to court that you can't decline. Footnote. This section distinguishes between statutory penalties for state-imposed debts and civil enforcement actions initiated by private creditors. 4. The 30-day clock. Once you get that intimidating letter from a collection agency, time starts ticking. Under federal law, you have 30 days to respond. This is where the Section 809 validation letter comes in. It demands proof of the debt, not recycled invoices or generic statements, but a signed contract linking you to them. Without that, the collector legally can't continue contacting you. So what does that actually mean? It means debt collectors must prove their story, and most can't. Footnote. This section explains the consumer's right under 15 U.S. C. Section 1692 grams, Section 809, to demand formal validation of a debt within 30 days of notice. 5. The letter that bites back. The 809 letter works like garlic to vampires. It stops phone calls, texts, and emails, forcing collectors to use certified mail. If they can't prove the debt, they must cease contact. Consumers should always send it by certified mail with return receipt, the famous green card, because proof of mailing becomes evidence later if the case escalates. Footnote. This section details how certified correspondence creates a paper trail establishing compliance with federal dispute procedures. 6. The signature trap. Never sign with your full legal signature. Unscrupulous collectors have been known to borrow signatures and paste them onto contracts. A single flourish of ink can become a counterfeit confession. Instead, use an initial or non-legal mark. And never, under any circumstance, send copies of your driver's license or utility bill. That's like handing them ammunition. Footnote. This section cautions against providing identifying documents or full signatures that could be misused in fraudulent validation attempts. 7. The address shuffle. Always use a P.O. box. Never your home address. Even if they already know it, you don't need to confirm it. The less personal data they have, the harder it is for them to drag you into local court. It's not hiding, it's smart logistics. If they have to work to find you, that's their problem, not yours. Footnote. This section advises maintaining privacy in creditor communications to limit exposure and protect against improper service. 8. The courtroom defense. If a lawsuit actually appears, the strategy shifts. Start by reviewing how the papers were served. If they were dropped on your porch or handed to a neighbor, that's not valid service in most states. File a motion to dismiss for improper service immediately. If service was proper, file a motion to dismiss for lack of standing, because unless the collector can show a clear chain of title from the original creditor, they have no legal right to sue. Footnote. This section outlines procedural defenses commonly used to challenge jurisdiction, service validity, and creditor standing in debt suits. 9. The silent killer, default judgments. Ignoring a summons guarantees a loss. The court rules in the collector's favor by default, often without you even knowing. Next comes wage garnishment, property liens, or frozen bank accounts. And if you also ignored your hearing notice? A bench warrant might follow. Suddenly, not showing up becomes failure to obey a court order, which circles right back to jail. Footnote. This section warns that failure to appear in debt proceedings leads to default judgments and potential bench warrants, reinforcing indirect debtor imprisonment. 10. The takeaway. Debt doesn't equal jail, negligence does. The key is engagement, not avoidance. Always demand proof, always document correspondence, and never ignore a court order. Knowledge doesn't erase debt, but it does keep the handcuffs off. So what does that actually mean? It means financial survival isn't about money, it's about procedure. Footnote. This section concludes that proactive participation and procedural awareness prevent debt-related incarceration in modern systems.